Hi, everyone. I'm Hana Kern. I'm going to be talking to you today about workplace investigations, giving you some practical tips, best practices, and strategies. Workplace investigations can be confusing. They can be a source of potential liability for your company. A botched investigation can lead to legal liability. On the other hand, a well-executed, thorough investigation can protect your company from liability. This is a broad topic. There could be an entire full day's presentation on workplace investigations. I am going to try to give you an overview, basically make you aware of issues, answer some of your questions, and generally just make you aware of the kinds of things you need to be considering when faced with doing a workplace investigation. All right, let's start with the process. The first step, you've received a complaint. How do you know if you have received a complaint which merits an investigation? First thing I'll tell you is that a complaint does not need to be formal. Your company may have a process requiring a particular form be completed, but the reality is the law says that anytime that you are made aware of an issue, you're deemed to know about it. So it could be verbal. You could have learned about it from a third party. So now you're aware of the issue. You next need to decide if it is something that you should be investigating. You have an obligation as an employer to investigate when a credible complaint is brought to the attention of HR or management. Keep in mind that not every gripe or beef merits investigation. Minor misunderstandings, personality clashes, you need to make a determination whether they rise to the level of something that requires investigation. Generally speaking, anytime that there is potential legal liability, you'll want to investigate. Claims of discrimination, claims of harassment, retaliation, violence, breaking the law, also ethical violations and safety violations. Those are the types of things that you will want to investigate. You'll want to notify the complainant whether or not you are going to investigate their complaint. There are lots of issues surrounding notification of the accused, and so I'm just going to touch on this. Generally speaking, you will want to notify the accused that they've been accused of something. On a practical level, you will be interviewing them, and so they'll certainly find out then. You usually wouldn't give them a copy of the complaint, although under some circumstances you might. One of the things that you should always keep in mind is that if the complainant or the accused are members of a union, they may have rights under the collective bargaining agreement at issue. So everything I say, keep in mind that if there is a collective bargaining agreement in place, it may put different requirements or greater, more stringent requirements on you as you investigate. Right, starting out with your investigation, you'll of course want to determine the goal. What are you investigating? What is the issue? Next, timing. The requirement is that your investigation be prompt and that it be thorough. So what does this mean? This is a fact-specific determination. As far as promptness goes, it really depends on the scope of the investigation. You could have an investigation of one simple issue that has a few witnesses. You might be able to wrap this up in a few days or a week. On the other hand, you might have a complex investigation with multiple issues, many witnesses, lots of documents to be reviewed, and that may take much longer. You want to be able to demonstrate that you are proceeding promptly, but there is no set, definitive time on which you have to complete it. As far as being thorough, this again, case by case, but you want to review whatever evidence is appropriate. That this could be documents, it could be interviewing witnesses. We'll talk a little bit more about that a little bit later. Some special concerns. So confidentiality, this topic alone could merit an hour's worth of time. So I'll just give you the 30,000 foot view on confidentiality. Generally speaking, the EEOC advises that requiring confidentiality during the investigation is appropriate. EEOC encourages employers to adopt confidentiality rules while that are applicable while the investigation is in progress. The NLRA requires that you not infringe upon people's rights to discuss working conditions. Prior to 2015, this was not interpreted to mean that you couldn't require confidentiality. And in fact, the NLRB said that you could give a confidentiality admonishment. This was then reversed, but now that pendulum has swung the other way, and you can encourage and admonish witnesses to maintain confidentiality during the investigation. Different issue for afterwards. NLRB says that confidentiality afterwards is appropriate only if the company can establish a legitimate and substantial justification which outweighs the employee's Section 7 rights. Finally, here in Washington, we have the Silence No More Act, still TBD on how that's going to impact confidentiality in workplace investigations. Very likely, you can't require confidentiality if the investigation involves conduct which the employee reasonably believes to be illegal, discrimination, harassment, retaliation, and the other things that are listed in that law. So, practical advice. You're walking a fine line between protecting people's privacy and conducting a thorough investigation, which does require and is best served by some measure of confidentiality. The complainant also wants privacy. I wanted to mention a little bit about privacy and particularly medical concerns. If you have an investigation centered around maybe disability discrimination, something that does involve a witness's confidential medical information, you want to be very mindful. Of course, as HR professionals, you are mindful of that anyway. So that doesn't go out the window when you're investigating. You want to the extent possible, protect people's confidences as far as their medical and private issues. One other thing I want to touch on here is changes in the workplace pending completion of the investigation. This is something to consider if you have someone accusing their supervisor of inappropriate conduct. Please consider whether it makes sense to separate those individuals pending the investigation. Is it appropriate to give someone a leave of absence? Maybe allow them to work from home? Is a temporary reassignment appropriate? One of the things, though, that I want you to be careful about here is be careful not to appear retaliatory. If you've got employee A accusing employee B of some kind of impropriety, you might decide it makes sense to take employee A off the big project that they're working on together. Well, is that going to appear retaliatory in that employee A is now being deprived of the opportunity to work on this particular project? So something to think about. Also consider who should do the investigating. And again, this is a case-by-case determination. But if the person tasked with investigating has personal knowledge or is somehow involved, especially if they happen to be accused, you wouldn't want them doing the investigation. Think about if they weren't investigating, would they be a witness? And if that's the case, you don't want them doing the investigation. So you'll need to find someone who can do it, who, best case scenario, really doesn't know anything about the situation or the allegations. One thing you can do is consider bringing in an outside investigator. This is a good idea if, for example, the HR department or someone in HR is accused, if there are likely to be allegations of bias, or if the investigation appears to be very complex, if there are lots of legal issues, you may want to bring someone in. If it smells like a lawsuit, this may be the time to bring in an outside investigator. So you're ready to go. You're going to start your investigation. What do you do first? Generally speaking, you'll want to gather documents. Again, case-by-case analysis on this. What do you need? What kinds of things are material? Are there emails? If there's an accusation of harassment, was this done over text, over email? If performance issues come into play, what kind of performance reviews are there? If we're talking about maybe a failure to promote, the allegation is there was a discriminatory failure to promote, do we need to look at that whole interview process and what the qualifications are of the individual, what the job requirements are, things like that. Once you've gathered your documents and reviewed them, you'll want to talk to witnesses. That is, that's not to say you won't later require additional documents, but initially you've gathered your documents. Now you need to talk to your witnesses. You need to decide who you're going to talk to and in which order. Generally speaking, it is a good idea to interview the complainant first. That really lets you know what they're complaining about. The complaint you initially received might be pretty sparse. You might not have a lot of detail. So this is a way to really allow the individual to flesh it out. And oftentimes you'll be told about additional people you should talk to. So as far as order goes, complainant is usually a good idea to take first. Oftentimes you'll want to take the accused last, but that's not always the case. So think about what information you need, who's going to be able to provide that information, and that will help you establish the order. Sometimes you may want to revisit and have a second interview with your complainant. That again is decided case by case. When you are interviewing folks, you'll want to obtain evidence as specifically as possible. And I'll touch on this a little bit later when we talk about the report. But generally speaking, you don't want just generalities like, did you see someone harass someone else? Yes, I did. What did they say? Well, they were very offensive. Okay, that's basically letting your witness decide what was and was not offensive. You want, what did they say? Where were you in relation to them? Could you see? Could you hear? So you really want to get as much detail as possible. And other investigative techniques, don't ignore, a site visit, right? Do you need to go to the place where something allegedly occurred? Is there physical evidence that's needed? So really think outside the box. So then after you have reviewed your documents, you've talked to witnesses, you've engaged in whatever other techniques may be appropriate, you're going to have to form conclusions. At this point, you want to be clear about what the accused is alleged to have violated. Is it a company policy? Is it a law? What is it? And then, of course, you want to consider the facts and credibility. As the investigator, you do need to assess credibility of witnesses. It is possible for you to conclude that you cannot assess credibility, but it's certainly something you need to delve into. So if you've got two people who are telling you two divergent views or two divergent versions of the facts, you want to do your best to determine which one to believe. And in your report, you'll want to explain why you made the credibility determinations that you did. And of course, you'll want to conclude whether a violation occurred. So let's talk briefly about the report. Generally speaking, your report will identify the issues. It'll summarize the complainant's concerns, and then it'll summarize your conclusions. Your conclusions can be a number of different things. You could conclude that the complaint was unfounded, basically that the statements and claims were found to be false or found to be untrue. You could also find that the allegations were not sustained. So you're not necessarily saying that the alleged facts weren't true, but you're saying that there was an insufficient amount of evidence to sustain the claims. So, for example, let's say you have a failure to promote allegation. The person did not get the promotion, and someone else got the promotion, and they're complaining that this was because of their gender or race or some other protected class. You may find that, yes, in fact, they did not get that promotion, but the complaint, the allegation is not sustained because the other person that did get the job was better qualified, objectively better qualified. And finally, of course, you can find that the allegations are sustained. In other words, a preponderance of the evidence does establish the claim. In your report, you'll also want to list the documents you reviewed and the witnesses that you interviewed. Any other investigative techniques that you undertook should be there as well. You'll want to detail your factual observations and findings. Make this factually neutral. In other words, it's not a lot of opinion in there. It's this person said that, this person said this. And then, but then you will want to, of course, put your analysis, identify if there were contradictions, if you made credibility determinations, explain why you made those. And then, of course, you'll want to analyze the facts, discuss the applicable policies, guidelines, requirements, legal standards, and explain your conclusion as to why those either were or were not violated. Finally, recommendations. Generally speaking, if there has been a sustained finding of some kind of violation, there will be a recommendation of some kind of action. It's fact specific and it depends on what was going on. So let's jump to some best practices. And so this is kind of an FAQ best practices combination. It's a combination of just things that I think you need to know and also things that I often get questions on. So do I need to do a written report? As with a lot of things, it's a maybe, but I want you to think about whether or not you need a written report. Oftentimes, if it's a complex investigation and there are allegations of legal violations of the law, you will want a written report, but you don't always need one. If it's something minor, you don't necessarily need to do that. However, even if you don't issue a written report, you definitely want to document your investigation. And this is one of the best ways that you can protect the company from liability. You're going to have solid documentation of the steps you took, why you chose to interview certain folks, why you didn't interview other folks, on what basis you made the credibility determination. So even if down the road, a court should reach a different conclusion than you did, the fact that you did a prompt and thorough investigation will protect the company. Just briefly on document retention, keep the documents having to do with the investigation. If there is litigation, they will probably be discoverable. Observers, supporters, or others present at interviews. I get that question a lot. This often goes back to a collective bargaining agreement, which does give the person a right to have their union steward or somebody there. But generally speaking, if someone wants a supporter at the interview, unless you have a good reason to not allow that, I tend to generally allow it. As far as closure goes, you do want to provide a conclusion to both the complainant and the accused. This does not necessarily mean that you're going to give them a copy of the written report, but you want to let them know what the outcome was. So very briefly on attorney-client privilege, investigations are generally not privileged. Even if you hire a lawyer to conduct your investigation, the material and the notes, the communications with that person are not going to be privileged. There's some nuances there, but for our purposes today, I just want you to be aware of that. As far as reluctant witnesses go, you generally can't force someone to talk to you. You don't have subpoena power. This is an investigation, not a court proceeding. Former employees or third-party witnesses, sure, reach out to them if they have material knowledge, see if they'll talk to you. The laundry list of people you must talk to. You may get a complainant that hands you a 3-page, single-spaced document. Here are all the people that you need to talk to. You don't have to talk to all of them, but you need to examine the list and decide why you are or are not going to talk to them. Finally, recording or transcription. So many complaints these days are done over Zoom, and so that is recorded. I generally do not make a practice when I'm conducting an investigation of recording it, but I find that that's a best practice. I do take notes, of course. I need some way to help me remember what everybody has said. So that's about all the time I have today. Thank you for listening. I hope I've left you with some valuable practical tips on conducting investigations. I'm available if folks have questions.